Hello. In this week, the topic in our MOOC is children's rights in connection with international criminal law, international humanitarian law, and human rights. This is the topic that we will try to address, considering in particular the practice and the work of the ICC. Talking about the rights of children in armed conflict, and so in connection with the situations that can be relevant in considering the cases of international crimes, we have to notice that in, let's say, classic international humanitarian law, the Geneva Conventions, the protocols, there is not such much space for the rights of the child. There are some provisions, for example, that proscribe enlistment, enrollment, recruitment of children under 18 years old. There is a clear prohibition of employing children under 15 years old in combat situations. But then the rest of the protection afforded to this population, this part of the population, is just included in the general provisions that protect the civilian populations in case of attacks and civilian objects, schools, for example, hospitals, and so on, in case of a conflict. The situations of children in armed conflict was also taken into account in the CRC, the Convention on the Rights of the Child, adopted in 1989. And this is quite important to underline because it is a case in which a human rights instrument, the Convention on the Rights of the Child, has some specific provisions, 2 articles indeed, that intrude into the area, into the field of humanitarian law. So the Convention on the Rights of the Child has indeed 2 articles that deal with the situations of children in armed conflict. So we may say that a human rights instrument includes provisions that are of international humanitarian law because they pertain to situations of armed conflicts. These 2 articles address the situations of children and say first that states cannot enroll, recruit children, that is people under 18 years old, in the armies, and second that children under the age of 15 cannot have a active participation in combat. So in a sense, these provisions just reflect rules that already existed in the field of humanitarian law and the Geneva Conventions and the protocols. Article 39 addresses a different issue, which is the rehabilitation of children who were victims of armed conflicts. And in this case, it covers entitlements and interests that are strictly related to the children's rights, let's say.
A shift occurred in the early 90s when the United Nations appointed in 1994 the Special Representative of the Secretary General on Children and Armed Conflict. The first Special Representative was Graça Machel. The report highlighted the disproportionate impact of war on children, describing the brutality millions of children caught up in conflicts were exposed to, and it demonstrated the centrality of this issue for international human rights, development, peace and security agendas. Children were identified as the primary victims of a conflict, and the Special Representative also included a set of recommendations to states. A children's rights shift took place in the way of addressing the issue.
So in 2000, we had 2 developments. One concerns the link between the issue of children caught up in war situations and the peace and security agenda of the UN, Security Council in particular. And the other development has to do with the adoption of a new instrument on children's rights and children's rights in armed situations, in armed conflict. Security Council Resolution 1314 of 2000 says that, I quote, the deliberate targeting of civilian populations or other protected persons, including children, and the committing of systematic, flagrant, and widespread violations of international humanitarian and human rights law, including that relating to children, in situations of armed conflict, may constitute a threat to international peace and security. And in this regard, the Security Council reaffirms its readiness to consider such situations and, where necessary, to adopt appropriate steps. This means that situations of organized violence and conflicts that affect civilian population and, in particular, children can trigger the initiative of the Security Council in the context also of Chapter 7 of the UN Charter. In the same year, 2000, the General Assembly of the UN adopted an optional protocol to the CRC, so the Convention on the Rights of the Child, a protocol on children's rights in armed conflict, involved in armed conflict, that it entered into force in 2002, and has special provisions that, in a sense, amend some articles of the CRC, stating, for example, that the minimum age to get enrolled and to participate in armed conflict, in combat situations in armed conflict, is 18 years old. So no longer the ceiling of or the limit of 15 years, but no children under 18 can be involved in these situations. And also states are invited to not to enroll any minor in their armies. The same provision apply also to non-state actors, a non-state group that participate in some in any internal conflict. And there are also extra provisions concerning reintegration, rehabilitation of children after the conflict has ended.
In 2005, the UN Security Council adopted another resolution, Resolution 1612, that creates a special monitoring mechanism on children and armed conflict. An annual report identified the states where conflict situation determine grave violation of international law to the detriment of children. States are explicitly named and encouraged to take appropriate measures. In 2007, in the framework of the United Nations, states adopted the Paris Principle Declaration. The declaration has the aim to combat unlawful recruitment or use of children by armed forces or armed groups. Quite comprehensively, the notion of child soldiers refers to, and I quote, any person below 18 years of age who is or has been associated with an armed force or armed group. The generic language used in this definition was meant not to limit the category of child soldiers to children who participate in combat, but include also sex slaves, porters, and others.